Hello everyone. Today in this session we'll be discussing important MCQs on Hindu law, family law. These questions are very important for LLB students as well as those who are aspirants of CLET and other competitive examinations. So without wasting our further time, let's start with the first question. First question is the Hindu Adoption and Maintenance Act 1956 applies to a Buddhist by religion, a Jew by religion, a Christian convert to Hindu religion, both A and C. See, in the definition of Hindu, Buddhist are included, a Jew is not included. A Christian convert to Hindu is also as reckoned as Hindu. So, Hindu Adoption and Maintenance Act applies to both a Buddhist by religion and a Christian who has converted to Hindu. So the answer will be both A and C. D is the correct answer. Next question. Under the Hindu Adoption and Maintenance Act 1956, which of the following is not entitled to adopt an unmarried person, husband with the consent of wife, wife who is divorced, husband without the consent of wife. The question is who is not entitled to adopt. Under Hindu Adoption and Maintenance Act, a unmarried person can adopt. A husband also can adopt with the consent of wife. Wife who is divorced is also entitled to adopt, but husband without the consent of wife is not entitled. So D is the answer. If you want to adopt either husband or wife, if they want to adopt someone, then they need the consent of the other. Husband need the consent of wife, and wife needs the consent of husband. So D is the answer. Under the Hindu Adoption and Marriage Act 1950, Hindu Adoption and Maintenance Act 1956, the requisites of a valid adoption have been laid down in Section 6, Section 5, Section 4 or Section 7. It is Section 7. In Section 7 of the Hindu Adoption and Maintenance Act, the valid adoption requisites have been laid down. According to Hindu adoption laws, which categories of females are permitted to adopt a child? Unmarried female, married female, widow or divorcee, all of the above. It should be all of the above. All these can adopt a child. In giving a child in adoption by the Hindu father, the requirement of the consent of the mother can be dispensed with if she has been declared to be of unsound mind by the court of competent jurisdiction. She has finally and completely renounced the world. She has ceased to be Hindu. All of the above. It should be all of the above. When she is of unsound mind, then it is declared by the court, and she has finally and completely renounced the world. She ceases to be a Hindu. All these are the grounds when a Hindu father can provide a child in adoption where the consent of the wife, that is the mother of the child, is not required. So it should be all of the above. Which one of the following is not correct? Under Hindu law, a person can be adopted if he is Hindu, unmarried, above 15 years of age, not already adopted. Which one of the following is not correct? It is asking about which is not correct. Under Hindu law, a person can be adopted. A person can be adopted if he is a Hindu, unmarried, above 15 years of age, or not already adopted. It should be C. It is asking about not correct. above 15 years of age, you cannot adopt a child who is above 15 years of age. Okay? Above 15 years of age, a child above 15 years of age cannot be adopted. So, which of the following is not correct? Under Hindu law, adoption is a child above 15 years of age cannot be adopted. This one is the correct answer. Which out of the following is not a ground which allows a guardian to give a child in adoption? Is not a ground. If both the parents are dead, if parties have finally renounced the world, if parents have been declared judicially to be of unsound mind, if parents are illiterate. It should be if parents are illiterate. This is not the ground for adoption, and in these all these cases, these are the grounds. If parents are both the parents are dead, then the child can be given in adoption. And if parties are finally renounced, this is also a ground. If parents have been declared judicially to be of unsound mind, if both father and mother of a child is declared of unsound mind, then the child can be given in adoption. If parents are illiterate, is not the ground. D is the answer. A Hindu man wants to adopt a girl child. Okay. The difference in age between the two should be a Hindu man wants to adopt a girl child. What should be the difference in age between the two? The age difference should be at least 21 years. A is the answer. There should be a age difference of at least 21 years if anyone wanting to adopt. A married woman can adopt a child with the consent of her husband. Without the consent of her husband, she cannot adopt, and none of this. A married woman can adopt a child, but with the consent of her husband. Under Hindu Adoption and Maintenance Act 1956, a child to be adopted should not have, in the absence of a valid custom, completed the age of 8 years, 10 years, 12 years, or 15 years. It should be 12 years. Hindu Adoption and Maintenance Act 1956, a child to be adopted should not have, in the absence of valid custom, completed the age of 12 years. Should be 12 years. Okay, next question. A boy of 16 years of age may validly be taken into adoption by law, by contract between parties, by consent of father of child, if custom or usage applicable to the parties so permits. It should be D. A boy of 16 years. That is, let's see the previous question. Under the Hindu Adoption and Maintenance Act 1950, a child to be adopted should not have, in the absence of a valid custom, completed the age of, it should be not 12 years, it should be 15 years. In the absence of a valid custom, completed the age of 15 years. That is, a child above 15 years cannot be adopted unless there is a valid custom for this provision. So, a child should be below 15 years of age if someone is wanting to adopt. 15 years is the correct answer. A boy of 16 years of age may validly be taken into adoption by law, by contract between parties, by consent of father of child, if custom or usage applicable to the parties so permit. That is, if the child is above the age of 15 years of age, If there is some custom or usage, then the child can only be adopted. So D is the answer. Widowed daughter-in-law shall be entitled under section 19 of this act to obtain maintenance from the estate of her husband, the estate of mother-in-law, the estate of father-in-law, the estate of her parents. It should be the estate of her father-in-law. Estate of her father-in-law. Widowed daughter-in-law shall be entitled to obtain maintenance from the estate of father-in-law in terms of under section 19 of Hindu Adoption and Maintenance Act 1956. A person shall be capable of being taken in adoption if he or she has not completed the age of 16 years, 18 years, 15 years, unless there is a custom or usage applicable to the parties which permits persons who have completed the age of 15 years being taken in adoption, or 21 years of age. It is 15 years. A person shall be capable of being taken into adoption. She has not completed the age of 15 years. A child of 16 years can also be adopted if there is a custom or usage applicable to the parties which permits who have completed the age of 15 years being taken into adoption. So C is the answer. Whether a valid adoption under the Hindu Adoption and Maintenance Act 1956 can be cancelled by the adoptive father or mother of any other person. Whether a valid adoption can be cancelled by the adoptive father or mother of any other person. It is no. Valid adoption has been done. This cannot be cancelled by the adoptive father or mother of any other person. This no. An adoption validity made can be cancelled by the adopter, the natural parents, both A and B, neither A nor B. The adoption validity made can be cancelled by neither the parents or nor the adopter. It cannot be cancelled. D is the answer. Where a Hindu who has a wife living adopts a child, the said wife is called the natural mother of the child, the adoptive mother of the child, the stepmother of the child, either B or C. It is the adoptive mother of the child. Till what period husband has to maintain his divorced wife? Till death, up to 3 years, until she remarries, up to 10 years. As per this Hindu Adoption and Maintenance Act, the husband has to maintain his divorced wife until she remarries. This is the answer. Which of the following section of the Hindu Adoption and Maintenance Act 1956 defines dependents? Section 24, 23, 22 or 21? It is section 21. Section 21 defines the dependents. A Hindu wife is entitled to claim maintenance after the death of her husband from her father-in-law under which section? Section 10, 24, 19 or 25. It is under section 19 of the Hindu Adoption and Maintenance Act. The wife, a Hindu wife, is entitled to claim maintenance after the death of her husband from the father-in-law as per section 19 of Hindu Adoption and Maintenance Act 1956. In Hindu law, a father-in-law is bound to provide maintenance to his widowed daughter-in-law out of his own resources if the daughter-in-law is not remarried, out of the copper scenery property in his possession, she is unable to get maintenance from her father, it should be out of the proportionary property of in his possession. The father-in-law is bound to provide maintenance out of the proportionary property in his possession. Following have the right to maintenance under the Act: wife, widow, daughter-in-law, legitimate child, widow or wife, widow, daughter-in-law, legitimate or illegitimate child, wife, widow, daughter-in-law, legitimate child, infirm parents, wife, widow, daughter-in-law, legitimate or illegitimate child, and infirm parents. Right to maintenance under the Act: wife, widow, daughter-in-law, legitimate or illegitimate child, and infirm parents. These all are entitled to maintenance under the Hindu Adoption and Maintenance Act: wife, widow, daughter-in-law, legitimate or illegitimate child, and infirm parents. Under which section of the Hindu Adoption and Maintenance Act 1956 a dependent's claim for maintenance under the Act can be created as a charge on the estate of deceased? Section 25, 26, 27 or section 28? The question is, under which section of the Hindu Adoption and Maintenance Act dependent's claim for maintenance under the Act can be created as a charge of the estate of deceased? It is section 27. Under section 27, charge on the estate of deceased can be created for claiming maintenance from, a dependent can claim maintenance from dependent's claim for maintenance under the Act can be created as a charge on the estate of deceased under section 27. C is the answer. Under the Hindu Adoptions and Maintenance Act, a wife will not be entitled to maintenance if she is unchaste, her husband has ceased to be a Hindu, she is suffering from a venereal disease in communicable form, or all of the above. It is talking about a wife will not be entitled to maintenance if she is unchaste, her husband has ceased to be Hindu, she is suffering from venereal disease in communicable form, or all of the above. No. If she is unchaste, then only she will not be entitled to maintenance. If she is unchaste, if she remarries, then in these cases she will not be entitled, otherwise she will be getting the maintenance. Which of the following disentitles a Hindu woman from the right to maintenance and separate residence from her husband? These are the reasons where a Hindu woman cannot claim maintenance, or these entitles, that means he loses her entitlement for claiming maintenance in case of conversion, yes, in case she becomes unchaste, or she remarries. In all the cases she will not be entitled to claim maintenance. So answer should be all of the above. A Hindu wife is not entitled for separate residence and maintenance if she becomes unchaste, ceases to be a Hindu by conversion, is living separately by her own violation, all of the above. It should be all of the above. If she becomes unchaste, she ceases to be Hindu by conversion, and she is living separately on her own violation, then in all these cases she will not be entitled for maintenance. So D is the answer. Under section 20 of the Hindu Adoption and Maintenance Act, a Hindu is bound during his or her lifetime to maintain his or her legitimate or illegitimate children, his or her aged or infirm parents, his or her daughter who is unmarried, all of the above. It should be all of the above. If It should be all of the above. A Hindu is bound during his or her lifetime to maintain a child, whether illegitimate or illegitimate, aged or infirm parents, a daughter who is unmarried, she has to maintain or he has to maintain all of these above. So answer all of the above is correct. Under which of the following section of Hindu Adoption and Maintenance Act 1956, Hindu is bound to maintain his or her aged or infirm parents? It is very important question. The question is, under which section a Hindu is bound to maintain his or her aged or infirm parents? It is section 20. Under section 20 of the Hindu Adoption and Maintenance Act, the Hindu is bound to maintain his or her aged or infirm parents. A woman cannot be made an accused in the case of a gang rape. The Supreme Court has held so in which of the following cases? Phul Kumari versus Nanduram, Priya Patel versus State of MP, Latha versus Union of India, or Lakshmi versus State. It is in Priya Patel versus State of MP. A woman cannot be made an accused in the case of a gang rape has been held by the Honorable Supreme Court in the Priya Patel versus State of MP. Dastani versus Dastani is the leading decision of the Supreme Court on the point of cruelty, desertion, insanity, or adultery. It is cruelty. Dastana versus Dastani is a leading decision of the Supreme Court on the point of cruelty. In which of the following cases it was held that matrimonial rights are not violative of Article 14 and Article 21 of the Constitution? T. Sarita versus D. Subia, Harjinder versus Harvinder, Saroj versus Sudarshan, Swaraj versus K.M. Garg. It is Saroj versus Sudarshan. In this case, it is held that matrimonial rights are not violative of Article 14 and 21 of the Constitution of India. Which of the following sections of Hindu Marriage Act was challenged in the case of Lakshmi Ammal versus Ramaswamy Naikar? Section 10, Section 11, Section 12, or Section 13? Should be Section 11. Section 11. By 2005 amendment of the Hindu Succession Act 1956, a son is liable to pay which of the following? Untainted debt of father, tainted debt of father, untainted debt procured by father before the amendment in the Act, or none of this. It should be untainted debt procured by father before the amendment in the Act. T. Sarita versus Venkata Subbaiah is a case relating to partition of property, conjugal rights, inheritance, or none of this. It is conjugal rights. T. Sarita versus Venkata Subbaiah is a case relating to conjugal rights. The constitutional validity of Section 9 of the Hindu Marriage Act 1956 was tested in Saroj Rani versus Sudarshan, Shakuntala Bai versus Kulkarni, Suristha Devi versus Om Prakash, Nanda versus Bina Nanda. It should be Saroj Rani versus Sudarshan, AIR 1984 SC 1562. Constitutional validity of Section 9 of Hindu Marriage Act. The leading case of Hindu husbands entering second marriage on conversion to Islam is Mohini Jain's case, Daniel Latifi's case, Sarla Mutkal's case, or Shah Banu's case. It should be Sarla Mutkal's case. In this case, the husband converted to Islam to enter into second marriage, as marriage is permissible, second marriage is permissible in Islam. In which one of the following cases the Supreme Court has directed that marriages of all persons belonging to any religion be registered in their respective states where marriage is solemnized if they are citizens of India. Seema versus Ashwini Kumar, Geetha Hariharan versus Reserve Bank of India, John Balamattam versus Union of India, and none of this. It is Seema versus Ashwini Kumar. Supreme Court has directed that marriages of all persons, irrespective of religion, be registered in their respective states in the case of Seema versus Ashwini Kumar. V. Tulasamma versus V. Shesha Reddy is the leading decision of the Supreme Court on the provisions of section 6, 8, 14 or 15 of the Hindu Adoption and Maintenance Act. It is section 14. It is section 14 of the Hindu's Adoption and Maintenance Act. Tulasama versus Shisha Reddy. What is there in section 14? Section 14 of Hindu Marriage, Hindu Adoption and Maintenance Act. What is there in it? This section 14 is talking about adoption. Who can B. Tulasamba versus Shesha Reddy is the leading decision of the Supreme Court on the provisions of section 14 of the Act. This section 14 talks about determination of adoptive mother in certain cases. Okay. The adoptive mother in certain cases, that is, where a Hindu who has a wife living adopts a child, she shall be deemed to be the adoptive mother. When an adoption has been made with the consent of more than one wife, अगर एक बीवी है, उन्होंने एडॉप्शन किया है, तो she will be the adoptive mother. अगर एक से ज्यादा बीवी है, the senior most wife would be called as the adoptive mother, और बाकी माओं को क्या कहेंगे? स्टेप मदर कहेंगे. Where a widower or a bachelor adopts a child, मतलब जो विडो है या कोई शादीशुदा है, उन्होंने एडॉप्ट किया है, एनी वाइफ whom he subsequently marries, उसके बाद में किसी को अगर वो शादी करते हैं, so he subsequently marries shall be deemed to be the stepmother of the adoptive child. अगर कोई विडोअर है या जो बैचलर है, वो एडॉप्ट करते हैं किसी को आज के दिन में, और उसके बाद में वो किसी को शादी करते हैं, तो दैट मदर विल बी द स्टेप मदर एंड नॉट द एडॉप्टिव मदर ऑफ द चाइल्ड. और एक ग्राउंड है, और एक ये है, वेयर ए विडो और एन अनमैरिड वुमन एडॉप्ट्स अ चाइल्ड, एनी हस्बैंड whom she remarries subsequently shall be deemed to be the stepfather of the adopted child. मतलब ये एक विडो है और अनमैरिड भी है, she adopts a child, and after adopting a child she marries subsequently, so the child adopted will not call the man as the man will not be called as adoptive father of the child, but he will be the stepfather of the child. The Hindu Minority and Guardianship Act 1956 is not applicable to scheduled tribes unless notified by central government, Jains, residents of the Union Territory of Pondicherry, or both A and C above. It is Hindu Minority and Guardianship Act is not applicable to scheduled tribes, okay, and the residents of the Union Territory of Pondicherry. Both A and C is correct. No person shall be entitled to dispose of or deal with the property of a Hindu minor merely because on the ground of his or her being the de facto guardian of the minor is provided under which of the following sections of the Hindu Minority and Guardianship Act, section 10, 11, 12 or 13. It is under section 11. No person shall be entitled, under section 11, no person shall be entitled to dispose of or deal with the property of a Hindu minor merely because of the ground that he is a de facto guardian of the minor. Okay. Under Hindu law, a mother in the absence of her son's father, that is husband, sells her minor son's immovable property. The minor son, on attaining majority, can challenge this transaction on the ground of not taking permission from the court, as the transaction was not done by his father, but he will be unsuccessful because the transaction is valid, as no such transaction can be done for minor son. It is on the ground of not taking permission from the court. In the absence of her son's father, that is, in the absence of her husband, the minor son's immovable property cannot be, or if she sells it, then the minor, on attaining the age of majority, can challenge this transaction for not taking permission from the court. As per Hindu Minority and Guardianship Act, a natural guardian has power to do all the acts which are necessary for the benefit of the minor, which are necessary for realization, protection and the benefit of the minor's estate, both A and B, or neither A nor B. It should be both A and B. A natural guardian has the power to do anything which are necessary for the benefit of the minor, which are necessary for realization, protection and benefit of the minor's estate. It is both A and. The natural guardian in any case cannot bind the minor by personal convenient. Correct statement, partly incorrect statement, partly correct statement or incorrect statement. It is correct statement. The natural guardian in any case cannot bind the minor by a personal convenient. It is correct. The natural guardians of a minor Hindu is the father and after him the mother in case of an unmarried girl, the mother and after her the father in case of illegitimate boy or an illegitimate unmarried girl, the husband in case of married girl, each one of the above in respective cases. It is the natural guardian is the father and after father it is the mother, and in case of unmarried girl, okay, the mother and after her the father, okay, in case of an illegitimate boy or an illegitimate unmarried girl, the husband is natural guardian in case of married girl, and each one of the above in respective cases. It is each one of the above in their respective cases. They all are guardian in their respective. This is the correct answer. which is not a guardian according to section 4 of the Hindu Minority and Guardian Act. Natural guardian, testamentary guardian, ad hoc guardian, a person empowered to act as guardian under any enactment relating to any code or word. It is ad hoc guardian, who is not a guardian according to section 4. It is the ad hoc guardian. This is not the guardian. Natural guardian is guardian. Testamentary guardian, a person empowered to act as guardian under any enactment by the court, is also a guardian. So under section 4, ad hoc guardian are the guardian. Under the Hindu Minority and Guardianship Act 1956, the custody of a minor who has not completed the age of how many years shall be with the mother ordinarily? It is under the age of 5 years. If a minor is of below 5 years, the custody of a minor who has not completed the age of 5 years shall be with the mother ordinarily. Disposal of immovable property of a minor by his natural guardian is valid, void, voidable at the option of transferee, voidable at the option of minor. It is valid. Immovable property of a minor by his natural guardian. It is valid transaction. The natural guardian of a minor Hindu boy is only mother, only father, grandfather, father and mother both. Father and mother both. The natural guardian of a minor Hindu boy, it is only the father. The natural guardian of the minor Hindu boy is only the father. But if the boy is of the age below 5 years, then ordinarily the mother will be the guardian. But as soon as the boy completes 5 years, the father will be the natural guardian. Only father is the correct answer. Under the Hindu Minority and Guardianship Act 1956, the custody of a minor who has not completed the age of 5 years shall be with the mother ordinarily. It is 5 years. Who is natural guardian of married minor girl? Father-in-law, mother, father, or husband? It is the natural guardian of the married minor girl is the husband. Maybe the girl is minor but she is married, so husband is the natural guardian. The guardian who doesn't possess the right of transfer of property of a minor is natural guardian, de facto guardian, legal guardian, guardian appointed by the court. It should be guardian. It should be the de facto guardian. It should be the de facto guardian. This de facto guardian do not possess the right to transfer the property of a minor. On which date the Hindu Succession Act 1956 came into force? It is 17th of May, 17th of June, 17th of July, or 17th of April. It is 17th June 1956. This Hindu Succession Act 1956 came into force. The Hindu Succession Act 1956 does not apply to the property of a person who is married under the Special Marriage Act, Hindu Marriage Act, Child Marriage Restraint Act, or none of these. The Hindu Succession Act does not apply to the property of a person who is married under the Special Marriage